Hello, everyone. It is 11 o'clock, so we will go ahead and get started. My name is Jennifer Erickson, and welcome to today's webinar on our Minnesota cannabis law and a reasonable suspicion. We'd like to thank our partners who help us deliver safety services and training to a variety of different companies. We work with TSSA, MPMA, SCSA, BIA of the Red River Valley, ABC, NRASP, Build Connection, and the Lake Areas Manufacturers Alliance. Thank you for your help and your support in delivering safety services. And we are your total safety solution. OECS, our #1 goal is to help employees return home safely every day. And we work with companies to provide those health and safety consulting services. So if you have any questions about safety services, find gaps in your own solutions, please reach out. We have offices in our Twin Cities and Fargo locations, and we'd love to talk to you about how we can support your safety. Your involvement is really important in this webinar. Please enter questions into the chat. Our panelists will be holding questions until the end, and they may very well cover any of the questions that you have during, but we'll address those questions at the end. And if we can't get to all of them, we'll be sure to reach out and make sure we're answering any questions you might have. We cannot share this PowerPoint presentation. However, a recording of this webinar will be available on our website within 24 hours. So we'll get it up Friday afternoon for rewatch. You can share that. Please get it out and rewatch if you need any additional information right on our website. Today in this webinar, our learning outcomes are geared around the legalization of marijuana in Minnesota, and it has introduced new challenges and opportunities for our employers. So within this 1-hour webinar, we're going to talk to leaders and HR professionals and help get a comprehensive understanding of how these changes impact workplace policies, employee conduct, and employer responsibilities. So our key learning objectives for today's webinar are to help you analyze Minnesota's marijuana laws to determine their relevance to workplace practices and compliance requirements, to apply state and federal regulatory knowledge to identify and address any compliance gaps, and to summarize the essential components of reasonable suspicion as a testing method. And we'll go more in depth on those things. Those learning outcomes are connected to the CEUs that we have available. OECS is an accredited ISET provider, and this webinar has been approved for 0.1 CEUs. We will be sending out an assessment and an evaluation to all of those attending live, and it will be available after the fact as well. And so once you've completed that assessment and evaluation, we will get you a certificate of completion. If you have any questions, please let me know. My email address is right on the screen, and we can help address any questions you have about continuing education units. And with that, I'll turn it over to our panelists.
Hello, everyone. My name is Dwayne Schmitz, Regional Lead Associate with OECS. I focus in general industry and construction and do reasonable suspicion training also. And with me is Connie.
Hi, I'm Connie Van Rolt. I obviously work at OECS as well. I've spent over 20 years in industry as human resources and safety. So I have done many of these trainings for companies all throughout the upper Midwest in relationship to construction or manufacturing, as well as some DOTs. So I'm excited to be able to work together with Dwayne here and answer some questions.
All right, we're going to start out with a polling question out there. Do you feel like you have good understanding of the Minnesota laws around cannabis use? So we're going to give a little bit of time here to go ahead and fill out the poll. Meanwhile, me and Connie have conducted numerous trainings throughout, like she said, the 5-state area, upper Midwest area, and we get a lot of different questions asked. So we kind of sat down and had a little conversation on what are some of the hot topic or the questions we get asked the most. And so we're going to kind of be moving through putting some of those questions out there. Hopefully we'll answer the questions and kind of shorten up the end for some of the more unique or dial in questions that maybe we didn't answer clearly. So with that, we'll be looking at the poll. And as of right now, we have a 75% state that they do not have a good understanding. So I hope we're able to answer some of those questions for you. So the first thing we want to start out is, it seems like Minnesota is implementing so many new regulations on employee drug testing. And so people are getting overwhelmed and trying just to keep up with it. So with that, we'll go on to Connie and address this.
So yes, Minnesota has enacted more rules than they've ever enacted. The Minnesota Drug and Alcohol Testing in the Workplace Act was enacted in 1987. Over the last 10-ish years, there has been 3 major revisions to that rule or to that act. One being in 2014 when medical cannabis became approved, 2023 when adult use cannabis became approved, and 2024 when we saw different testing procedures that were approved that we will talk about as we go through. So it is really confusing for people, but understanding that the Minnesota Drug and Alcohol Testing in the Workplace Act still stands today. And the reasons that it stands is because it's there to ensure that we have a fair and balanced approach to workplace drug and alcohol testing and making sure we're protecting employees' rights while maintaining a safe and productive work environment. So I can understand why people are kind of confused.
There's a lot of information that's changed recently compared that it has not been touched on or really revised in so many years from when it first was introduced.
Right. And another question that I get all the time is, how do I know if I have to do this? How do I know if I qualify or I have to follow these regulations?
Well, so the way it goes, it applies to all private sector employers in Minnesota, also to the public sector employees. And there's just some different rules and protections that apply between the 2 different ones.
The majority of our clients, majority of private or all private sector, this Drug and Alcohol Testing Act does apply to you.
So another one that we receive is the medical cannabis requirements. A lot of people are wondering, do I need to allow my employees use this whenever and wherever they want? How does that apply into my work environment?
So no, medical cannabis, when employees become or people become patients under the medical cannabis rules in Minnesota, they are given information about not using in certain locations. One of those locations is that they are not allowed to use in the general public or at their place of employment. So you shouldn't see any vaping or smoking or employees using prior to going to work or while at work as if they were approved for the medical cannabis program. Another question that is often asked is, does medical cannabis fall under the American with Disabilities Act? Like, do I have to, are they protected? And the real answer is no. The American with Disabilities Act is going to follow federal regulations. And right now, federally, cannabis is a Schedule I drug, which means that it is illegal in a federal type environment. With that being said, there is an idea or there is an act or a process going through that they're asking for it to be moved to a Schedule III drug, which is the same as like Oxycontin. The reality is that the American Disability Act is never going to allow employees to come to work impaired. So even if it is a Schedule III, it isn't something that employees will be able to use, possess, sell, transport, be impaired by, or if I do safety sensitive work, will be allowed to use during my employment. Because medical cannabis, the rules are specific to Minnesota, we want to make sure that we do call this out in your policy and speak to what your practice is. If you have safety sensitive positions, it is best to ask employees to ask for accommodation if they are planning to use medical cannabis. as it could cause impairment, and employers should be able to understand whether or not they would have a position that would meet the requirements of that. So it isn't something you just have to just take on. You have to understand what's going on with the situation. So, make sense?
Sounds good.
Aren't there other states that have already done this? Like, why do we see such changes?
Well, for us, we are, as of 8/1/2023, the 23rd state to embrace the legal medical marijuana for recreational use. The big thing when we're looking at medical marijuana and the positive drug testing or the drug testing is the impairment factor that comes with it. So with it being used for recreational, just having a positive drug test does not warrant the possible disciplinary actions. So we need to look at, is there impairment with it? It has to be supported. So we will be talking a little later on regarding what you want to look for when it comes to the impairment areas and how to possibly document those to make sure you're protected and you're using the right process.
Yeah, and just to clarify, when Minnesota being the 23rd state, we allowed medical and recreational, so adult use. And it really does speak, and we are looking more at impairment now than we ever were before. So another question that I get is like, what does this approve people to do? Like, you know, what does this policy say? So effective August 1st, there's a full decriminalization in Minnesota. It will allow employees to possess, use, home grow cannabis for people age 21 or older. So really, in my off work hours, I can use, possess, transport, grow marijuana or cannabis.
And so we're capturing here just some of the things outlined. So the transport up to 2 ounces of cannabis flower, possess 2 pounds in the private residence, transport up to 8 grams of adult use concentrate. Again, the edibles is another thing that's out there, and that's a combined 800 milligrams. There's a lot of different levels, so you need to be aware of what the content is. And then allowing to give it away to another 21-year-old is another part that goes into it. So what I run into also are what are the changes in employer drug testing law that happened when Minnesota legalized adult cannabis use?
Yeah, so that's a great question. So as we said before, Minnesota has always, protected the employees' rights, and they continue to do that. So protections for job applicants and employees who use cannabis during non-work hours. You can't refuse to hire or discipline or fire an employee solely for using off-duty cannabis. And you can't require pre-employment cannabis testing or marijuana testing, except for in certain safety sensitive positions.
So for safety sensitive positions, what does that mean?
So what that means is it's any job in which impairment caused by drug, alcohol, cannabis use would threaten the health or safety of any person. Also, police officer positions, firefighter positions, any positions that require face-to-face care, training, education, supervision, counseling of children, vulnerable adults, or patients.
So employees cannot be penalized for illegal off-duty cannabis use as stated here, unless impairment, again, documenting, understanding, seeing, noting, and then having multiple people do it. So training and reasonable suspicion is a key thing to identifying the impairment. Or testing confirms cannabis presence along with impairment. And then the job is a federally regulated, which we'll talk about how that affects into the DOT and federal contracts.
So just to refresh this, so if somebody is impaired at work and you have information talking about their impairment and they have a positive drug test, then they can be penalized. So this is speaking to, we still can test and discipline employees. So if you deem roles to be safety sensitive, like I just described, or you work in an environment that has federal drug-free workplace compliance, which speaks to having a federal contract, then you still can drug test. My best practice for this is, instead of looking at the person that is applying for the role, look at your jobs and determine if they are safety sensitive or not, and have that as part of your job description, so that whenever you're hiring for the different roles, you're aware if it's a federally regulated situation or if it's a safety sensitive position, and then you could drug test those for those positions, not based on people. So here are the exceptions. These are the ones that I just covered, but understanding, yes, you can test if somebody has safety sensitive positions. So we work in construction and general industry all the time. What are some safety sensitive roles that you've seen?
I've seen people operating machinery is a big thing when I go out to the construction sites. General industry, they're working in the production line, operating company vehicles. Anything that puts them into a position of a risk hazard for them and or others around them.
Right. So you want to evaluate your jobs, understand what is truly safety sensitive and then what is not, and make sure you have a good understanding of that. And that should be outlined in your policy, as well as what are the positions that we've deemed as safety sensitive. One note to make sure you understand. So if I supervise or manage someone else and that impairment would cause problems, I could potentially be in a safety sensitive role as well.
So what if I just come in and I work in the front office and I'm mainly doing scheduling and some paperwork?
Yeah, if you don't have any like machinery that you're running, or you're not working in a job site, like going out into the plant or going out onto a job site, you wouldn't qualify for a safety sensitive position. And that's why it's important to look at the jobs and not the people that are in these jobs, but really look at what are the tasks that they are doing to qualify to be a safety sensitive role.
So I work in the office. Once in a great while, maybe once, twice a year, they ask me to drive a company vehicle to take some products somewhere else. Would that then put me into a safety sensitive position?
Yeah, as soon as you drive a company vehicle, anything that would be related to doing safety sensitive type work, such as if I were to get in a vehicle accident and I was impaired, I could cause injury or harm to others, that would put me into that situation. What I can tell you though is look at do I really need to do that twice a year? Is there somebody that's already in a safety sensitive position that should be maybe doing that task, so that you are being fair and equitable to all employees? So
we go into the exceptions for the pre-employment or routine testing. Employers may continue pre-employment or routine cannabis testing for the following: funded by federal grant. So this is another area you're going to have a good understanding of the funding or money or projects that you're doing, and do you fall underneath the federal grant and or federal contract. Federal contracts over $100,000 do fall under the Drug-Free Workplace Act of 1988. And so the communication is a key thing to make sure that you know where you lie, and then also capture that in the policy for your company.
And with this, you might have two policies. So what this is saying is that if I have employees that, due to the work that we're doing, we either have a federal contract that's over 100,000, or I'm working on a project that has a federal contract over $100,000, or any grant from the federal government of any amount, the rules under getting grants or federal contracts states that you will implement a Drug-Free Workplace Act, which speaks to the fact that people can't use cannabis or have any test results of positive for anything. You would be required then to potentially have two policies if you have people that work on federal jobs, and then people that don't work on federal jobs would follow state rules. But anytime you get into this federal regulations or federal rules, they are going to supersede Minnesota rules. I often hear people like, really, people still can test for drug and alcohol and cannabis, like pre-employment, like that doesn't make any sense. If the company is getting a grant or has a federal contract, they have to. I've worked in those industries. I know that if you don't follow that, the federal government will look to you and ask you, to let that person go or discipline that person to ensure that you're getting your money, right?
But Connie, I'm just a subcontractor, and I'm just bidded out this job and I'm doing it for a set local general contractor. And I don't have to fall underneath that act, do I?
You do, because let's pretend you're going to a post office and that's where you're doing subcontractor work. Because the money is coming from a federal regulated pool of money, people that work in that environment have to follow the Drug-Free Workplace Act. So you would, as the subcontractor, your GC should be telling you, hey, we have to follow these rules, which means you have to follow these rules. Often I will see subcontractors, smaller groups, get a few or a number of employees through this process and following that rule, and then maybe have a separate policy for people that aren't going to work in a federal or federally funded environment.
So it's probably something then that I should ask as a sub regarding that. Is it under a federal contract that may affect my company policy?
Yes, because they will ask you to remove that person if that person is impaired or ever test positive.
Great.
Another thing that you have to consider is if I have a CDL license, that all falls under the DOT, which again is federally regulated. Usually CDL drivers will have additional requirements. They are usually subject to random drug testing as well. But those are people that you wouldn't want to like, oh, you don't have to drug test, or we don't have a policy. The people that have CDL licenses actually do have to maintain that CDL license. And in order to do that, they would need to be drug, alcohol, cannabis free.
What if I just say my policy is the DOT regulation and that's it?
Not everybody would fall under that policy due to the rules that apply for that. So you can't blanket everybody, because you're going to run into issues where if I am not in a safety sensitive position, or if I'm a non-DOT driver, like those rules don't apply to me. I might be in a safety sensitive position, which then could speak to the fact that you could drug test me, but you need to declare that. You can't just put everybody under a federally regulated realm unless you have these caveats, because Minnesota rules then would apply in that situation. Right. It doesn't just blanket you out of Minnesota rules.
Okay. Because that is great information. And one thing we realize that some people do not realize when it comes to the commercial motor vehicle is getting the fit for duty or the med card. And so I'll go out to job sites and I'll see them having a pickup with a trailer with a bobcat on it, or they're using a box van to move material and pallets around, and it's exceeding that 10,000 pound limit. And a lot of people don't realize that that is the point to where you have to get a med card. DOT going for your physical, and part of that physical is drug testing.
The part of the physical is that they have the right to drug test you. An employer doesn't have any say in any of this. What happens is that they go in and a certified medical examiner is going to make the call on whether or not drug testing will happen for this person. It isn't part of the normal protocol. However, to get a medical card, they do have a form you have to fill out, and it will ask you about if you have taken any Schedule I drugs, which includes at this point marijuana, cannabis, everything that falls into that. And that is an automatic disqualification. I know right away when we started, or the law had changed. And we had a company give us a call and they're like, we didn't know what to do. So we told everyone they could do what they wanted on the weekends and no problems. But we didn't realize that we didn't think about the fact that we had some CDL drivers and some medical card employees that actually fall under a different entity. They fall under the federal regulations. There was an accident and a person that did have a medical card actually got their medical card revoked because they were positive for cannabis. Can you imagine? That employee was so upset with the company because they had thought they were given free rein, but then to find out that they weren't even under the right policy. So be careful for stepping completely away from this. You do need to engage because there are a lot of requirements, but you need to understand your positions and then understand how you are going to follow Minnesota law. That's a lot of this has existed for years and years. So
Again, it's awareness and asking questions. It's new and it's evolving, and we need to look at the full scope. We just can't take from Minnesota. There's a lot of things that lead in from federal, state. And so awareness, understanding, and training is very, very important to stay on top of this, to not only protect the employer, but also the employees. For this instance that you talked about, that employee, unfortunately, had a disciplinary action due to the employer passing wrong information or not being familiar with the laws. So we want to make sure we stay current on that at all times.
And then, another law that went into effect, that was on the books to be into effect, but then never went through until 2024 was where we had oral fluid testing. So I know for years people have asked to have oral fluid testing, and what that is you can do a mouth swab for drugs, alcohol, and cannabis. And now this is approved in Minnesota. Minnesota has always taken the stance that you have to go and have your testing done at a certified lab. And those were the only test results that Minnesota would look at. Now, employers can have this part of their program where instead of sending them to a clinic, they would do an oral test. So they would swab the employee's mouth, and you can do this for any of the testing reasons. So pre-employment, post-accident, reasonable suspicion, any of the reasons that you would do. But there are some caveats with this. One, employees must be informed prior that this is going to be how you're going to test. Two is if an employee tests positive within 48 hours of that oral test, if it is positive, inconclusive, or invalid, the applicant or employee may request a drug or alcohol cannabis testing at no cost to the applicant or employee using a certified laboratory. So again, if you do implement this, you still then would need to follow up if they are positive or if it's inconclusive or invalid with having them go get another drug test taken care of.
Do you know the person who would be applying this, do they need any advanced training on the equipment?
So it is pretty straightforward. There are companies that make this swabbing tool basically where you would they will train you on how to do it. A lot of the training, what I have found is really, you watch this YouTube video and you're pretty good, just due to the fact that it is a pretty basic situation. The only concern is that these tests are going to be permitted and valid. So if somebody does, it is very easy to test. So you still have to follow procedures. You can't just line everybody up and test them all. You have to make sure you have a reason why you're testing, and that reason has to be supported. We'll talk more about that. So don't think that this is just everybody's going to have a quick test done, then you're going to see what happens. You have to have more of a reason, like just in every other situation. You had to have a reason to send them to the clinic. You have to have a reason on why you're testing them.
So we don't want to go ahead and just say, I want to test all of our employees and have a baseline and see what's out there, and we're all going to run through this.
not legally in Minnesota.
All right.
Like, no.
I just want to make sure. so.
Yes, yep, no, it's not a good plan. So another piece that is often asked is, what does OSHA say about all of this? So, this seems really confusing, but what is OSHA's stance?
The key thing here with what OSHA says is the impairment. So with the legalization of recreational use, you need to have impairment signals, observations on top of a positive drug test. So if an employee is impaired while working due to drugs, cannabis, alcohol, that is an issue. And that can also turn into, if you have an employee out there and you do not see the symptoms or they are demonstrating that cause an incident or accident, it could fall under the general duty clause, and you could find yourself getting a citation. So we're always ensuring, that's why we like to have supervisors and the managers trained in this area, so they can always be keeping an eye out to ensure we always have a safe working environment. And then if we do see any impaired risks, being proactive on it and catching it before an incident, accident, or something happens. So
let me just understand. So if I have an employee, let's pretend they had an accident.
Yep.
And I find out that they, it was a major accident, major incident, and they did major damage. OSHA, and they have a positive test result. OSHA's gonna tell me like maybe that wasn't because of their impairment.
So what OSHA will do in the investigation is they'll ask if there was any signs or symptoms demonstrated by the individual that would raise alarm.
Right.
So if there was,
Gotcha.
because due to recreational, they may have indulged over the weekend and had zero effect. Or were not under that influence or demonstrating any impairments at that time.
Gotcha. So that's one note that you're gonna wanna make is, you do have to pay attention. Impairment is really the keys to what we have to take a look at.
So after talking about leading up to where we're at now, a lot of information giving out. So is there anything else I should know about drug and alcohol testing in the Workplace Act?
Yeah, so most people don't understand that this act has been around since 1987, and this has always required us to have in industry a written policy that outlines the circumstances under which we're going to test, what substances we're going to test for, what happens if somebody has a positive result. It is in Minnesota is very well written out on how this policy must look. I would go to employers that have one sentence or 2 paragraphs, but no policy. That is not going to hold up. And especially as more and more things continue to happen in relationship to drugs, alcohol, cannabis, especially cannabis being legalized. If your policy doesn't fit Minnesota rules, it will be very hard for you to say that you actually have a policy if you are ever going to court, or if you ever improperly tested somebody, your policy should define why you test people. So you want to make sure you have this, and you must inform employees of their rights if they are going to refuse a test or what happens if they do refuse it. This policy needs to be posted. It needs to be in a conspicuous area, or if you don't have a conspicuous area because you're on in a job trailer and you can't put it in there, if you have like a QR code or however you typically make sure people can see documents from your company, as long as it's there, you'll be okay, and as long as people know where to get it. But they should have access to it all the time. People also, your new applicants, all employees have to sign a piece of paper stating that they have received your drug and alcohol cannabis policy and that they are aware of the fact that you have a policy. This policy is truly your roadmap on how you're going to handle different situations as you will have working with people. So
our company is just adopting and putting this in place. And so we're presenting it to our employees, current employees, and I have a couple that refuse to sign this new policy.
So
what can I do?
So it's going to be a little challenging. because you didn't make it part of their agreement when they started working for you, you as a company have the right to change, your policies. So you're going to have to get them on board to sign this policy, being aware of the fact that they're going to have to follow suit with everyone else. So if they fail to follow the policy, you'd have to have conversations about what would happen next.
Repercussions.
Yeah.
So we get into the policy definite in different areas that you can do the testing. And so we're just going to touch base a little bit on the different styles. So the pre-employment testing, do I have to test for cannabis in a pre-employment?
Great question. It's a question I get all the time. So your policy has to define when you're testing and what you're testing for. So do you have to test for cannabis or marijuana in pre-employment? No, but your policy needs to state that, okay? If you choose to test for cannabis in another reason, such as reasonable suspicion, then you have to make sure that that's clearly defined in your policy. You can have different drugs or different substances that you're testing for different circumstances, but you can't willy-nilly do it. I also have heard of companies saying, well, I'm just not going to look at the results. I'm going to get the results for cannabis for pre-employment. I'm just not going to look at them.
Mm-hmm.
I would be careful of, I would talk to your clinic, I would talk to whoever and try to only get the results of what you want to get. Because if there was a long-standing issue of, okay, well, we didn't test for it, but this person later on had a major incident, there would be a question potentially because it's documented about they did test positive prior to employment, even though you didn't look at it, you have the results.
Right.
So,
go
ahead.
We get into the random testing. Again, safety sensitive positions has to be outlined again in the policy. We're beating that up a little bit or really emphasizing it. It's very important your policy supports, like Connie said, it is your roadmap. So the random testing for employees, safety sensitive positions, and then we move into the reasonable suspicion, which is another one where training is key to make sure that you are uniformed on this for reasonable suspicion.
Yeah, and I just want to go back to random testing for just a second. So I've worked for companies that want to make it fair and equitable for all employees. So they want to put all their employees in their random testing pool. Minnesota is very clear and always has been, but very much more emphasis on safety sensitive roles now than ever, that it can only be people that are in safety sensitive positions could you implement random drug testing for. So you have to be really clear of what you're doing, because if you blanket it, you are going to run into trouble, especially now as there is such a definition for safety sensitive.
How do you come up with the random testing list or name?
So you have to work with a third party group that is going to manage that for you. People that work at a company cannot be part of the selection of employees. It has to be a third party that is going to manage it, and the employer should not be privy to who's on the list until then the name is called from a third party person.
Because I've had someone there looking at going to the random and they're stating that how they would select their own employees for the test.
No, look at Minnesota law. It is very specific and tells you exactly how you would need to implement random drug testing, but it isn't that you can choose. It is a process, and maybe another day conversation, as we want to really cover reasonable suspicion today. But yeah, random drug testing, if you have questions, reach out, but it is its own little, it's a beast a bit.
It is.
Yeah.
It is very much so. We get into post-accident. Again, what Connie stated earlier, you might use a 5-panel test at hiring. This one might be a different panel, 7, 10, 12 panel testing. Again, identify it in your policy, make sure it's part of the sign signature, make sure the clinic understands what you'll be testing for to make sure you get the proper results back.
Or if you do your oral swab, make sure that you're identifying what you're testing for. And then return to duty and follow-up are typically done if someone were to test positive or if they've been off from work for for another incident, you could have these written in your policy as well for additional testing purposes.
This is what I talked about earlier, just the different panels out there, just make sure you have those properly identified in your policy for different parts of the testing process.
So I just want to hit on pre-employment because of the change a bit due to Minnesota rules or Minnesota laws changing. So pre-employment testing can occur for exception positions, which is really that safety sensitive police officer, that list that we went through earlier. But it can only occur after a conditional job offer has been made and that you state that is contingent on a successful completion of that drug and alcohol cannabis test. Your substances, again, they can be different, but you have to outline what they are, and you can test any either orally or at a clinic. And that's going to be based on your policy and based on what you're working for. Prior to pre-employment testing, new candidates need to sign off that they understand that you have a drug and alcohol testing policy, and they should have access to your policy, and that they are being tested due to, if it's safety sensitive, you should be calling out. If you're federally regulated, you should be saying that as well, and that's the reason they're being tested. So you're very clear. Then we get into reasonable suspicion, and this has changed a little bit only due to how it's now being looked at per law. So an employer may request or require an employee to undergo cannabis testing and drug and alcohol testing if the employer has reasonable suspicion that the employee is under the influence of drugs or alcohol or cannabis, or has violated the employer's written work rules prohibiting use, possession, sale, transfer of drugs, alcohol, cannabis, flower, or in your vehicle. So if you are planning that you are not going to allow employees to use, possess, use it in any part of your facility or in your vehicles, you have to define that in your policy. Under reasonable suspicion, they have now put in personal injury and work-related accident or incident that has caused harm to something or a piece of equipment. So that is now under reasonable suspicion. So before, those used to be separate pieces. Now in Minnesota, they are all reasons to test under reasonable suspicion. Reasonable suspicion, it has to be based on logical reasoning, and it has to be facts and evidence. It can't be, oh, you smelled like cannabis today, so I'm going to go in and get you tested. Odor alone is not a reason that you can test. Odor does not speak to impairment. Impairment also isn't, I have hoodies on, or I wear a hoodie, and I have a weed flower on my shoe. Whatever it is, that is not saying that I'm impaired. So whenever you think about this, you really have to speak to the fact of what were my behaviors, what did I look like, what did I act like, that has caused you to believe that I could be potentially or impaired by something. Whatever you're going to test for in reasonable suspicion, again, outlined in your policy. And again, however you're going to test, either orally or send me to a lab, needs to be outlined in your policy.
Then we get into the training for the leaders or the people that are responsible that you're going to identify as maybe observing the reasonable suspicion and trying to document it. So the number one thing is you have to understand the policy. I've been to a couple places and I asked, please outline your policy, your current stance. And half of the leadership was not able to articulate anything from their policy. So the big thing is this: understanding your policy and then going through the training and understanding what impairment signs are. Allergies can make eyes red and bloodshot. There has to be more than just one. Normally you want to make sure you have multiple different areas of concern. You know, if you receive a complaint, how do you assess situations? So again, it comes into the training area for the reasonable suspicion and making sure you document the individuals that have gone through that.
Yeah, you want to make sure that your leaders know your policy. One thing that we do, or that Dwayne and I do all the time, is If you're gonna get reasonable suspicion training from us, I'm gonna ask you for your policy because we need to train your employees on how to navigate your policy because it's really your roadmap. So if you're not spending that time to teach them about your policy, if you're not spending the time so they can understand what impairment looks like, they're gonna have a hard time ensuring they have a safe work environment when they don't know what's going on.
What to even look for.
Right.
That takes us into the document. So we have a little sample here, reasonable suspicion observation. When you're doing this, you want to do it individually. So the big thing is you receive notice, a complaint, you notice someone acting different. What do? You can take out this reasonable suspicion observation. You want to start looking through and determining what you have. Documentation is a key thing. You want to put in there the time, the location. What are you observing? Any other witnesses around, and use that as an individual base. You want to also then contact or have another person that's trained to do a document independently from yours to determine, are they seeing the same thing? Maybe the individual was just unbalanced or something different. So you want to have two different people do it on their own. Then you want to compare your notes. Once you compare the notes, then you're going to want to look at, what do I do? How do I go? What do I see? Talk to HR and see what the next step will be.
So, yeah, so as we speak through this, what will help you the most is get to know your employees. What you're looking for is a change in behavior for a majority of the employees. Now, having a new employee makes this a little bit more difficult because you don't understand what their normal behaviors are. However, there are some very specific signs of impairment. And we're going to cover the cannabis signs next, just to give you some indication. This is just one portion of the training that we do. But because we're speaking to cannabis, we want to make sure you understand the signs. So moving into the signs. So these are always going to be separated by different things. So behavior, speech, and appearance. So to give you some indication, so my emotional behavior doesn't match the situation. How are you ever going to find that is, I always say, this doesn't have to be super challenging. What you're going to do is you're going to go and have a conversation with the person. Make it normal. Make it what you normally would speak to them about. If you're going to normally speak about how great the Vikings are, which maybe is an issue, but if you're normally going to speak about that, then that is a normal conversation. What you're looking for is, do they seem different? Does it feel like they have loss of coordination? If they're moving around and they're kind of stumbling around, these are things during that conversation that you're going to pay attention to. If they lose focus, like they can't remember what you were talking about, it's just an indication that maybe there's something going on here. If they're having difficulty thinking, you're going to be able to see these things just by talking to somebody. It doesn't have to be like, hey, Dwayne, are you doing drugs? Because you're probably not going to get the best result that way. What you just want to do is understand what's going on and have a normal conversation, looking for slurred speech. Looking for a great one is dilated pupils. Dilated is like the photo that you see there. My pupil is very large. That's a pretty good indication. You cannot just use odor, but if you have odor and something else or a couple of the others, which usually if you have odor, often you will have dilated pupils. It's very commonly go together. These are things that you're going to make note of.
So key things to take away: know your employee.
Yeah.
So you can identify a change.
Yep.
Probably don't walk out with the observation sheet and stand and look at them.
Right.
Take mental note. And walk away and see if it makes sense to continue.
Right. And have somebody else go talk to them. Kind of same idea. Have them, see if they notice anything. Don't give them information. Have it be a blind conversation, just like you had. But we're really just trying to understand what potentially is going on with this person.
Correct.
So people ask me all the time, like, really, we have to go through all this training and like, it's just weed. What's the deal? Like, this is silly.
I agree, but a lot has changed with the product itself. So before is not what we have now. So what we're showing here, the ditch weed, super weed, back then 3% best potency, not really associated with a ton of impairment. But now the THC levels are increasing. So I kind of always put this into alcohol. So if we're sitting in the 60s, 70s, approximately through 3%, that's about 20% alcohol in a drink. 2012, we're up to 12. So now we're getting into like the 40. And today now we're at a solid 60, 70. And the big thing that comes with this is they have not been able to study it. So we don't have enough information right now. And what it means with these higher percentages is the higher the dose, the longer the high, and the more intense the high. So those are areas we got to look at it. It's not, hey, back in the 70s, we used to do it. And I don't know why they're making a big deal of it now. It's just that with the strength at the level it's at, everything now is greater. The highs, the intensity, and
They used to say if it was above 15%, it was extremely high, and now we're averaging well over 20. Even my can of water that we have on the sheet, or on this thing here is at 20 milligrams, 20%. So we're getting out there, and it's getting higher and higher all the time. So it isn't the same ditchweed that you had when you were younger. So walking through the situation, we do have to ensure our leaders are understanding how to assess the situation. So if I go through the process and another person goes through the process and we go talk to this person, and the first thing that we're going to do is meet and discuss what we noticed. We're going to review a checklist, probably phone a friend at this point, and call HR, call a leader. Understand what your policy says, because your policy is what's going to govern how you move forward. Whenever we're doing this, we don't want to make assumptions. I know sometimes assumptions are easy to do, like, oh, this person is definitely doing something. Well, maybe, or maybe they have a medical condition. We need to take a step back. We need to figure out what our policy speaks to and how are we going to move forward. When we do go to conduct the conversation, it is important that we think about some things. Dwayne, what are some of the things that we have to consider?
so when we're looking at having the conversation, we want to stay calm. We cannot be emotional. We cannot jump prejudging. So we want to stay calm and professional in a private setting. Again, bring them in, discreetly, not drawing attention to them. Express the concerns of the things that we found, the facts, what we noticed, and then allow the employee to explain. That's a big thing, is let them have a moment to try to explain or disclose relevant information. It could be medication. They may have just changed that up and they're having effects that they don't even realize. So again, that's a concern. Avoid altercations, right? Frame the conversation around the safety and well-being of them and everyone around them, because people will be more open to that conversation.
And then next, you're going to make a decision on your next step. If you think of impairment is confirmed or it's strongly suspected, again, take a look at your policy. Your policy should tell you what you should do. Always, even prior to this, obviously, removing that employee from safety sensitive tasks immediately. If your policy says you need to arrange for a drug, alcohol, cannabis test, you need to figure out how you're going to do that. Usually policies will describe transportation, or at least leaders need to understand how are you going to transport them if you're transporting a person, because you can't let a potentially impaired person drive. Again, your policy will tell if they say, I'm going to not take a test, I'm going to refuse. Your policy should say what happens next. So make sure you have a good understanding of what are the next steps. How are you going to get through that? Additionally, usually you're going to wait for test results from whoever's testing, or if you're testing orally, obviously you're going to get those results pretty quickly. And we need to maintain that confidentiality. After we have this information, then once you receive the results, Minnesota's law says that within 3 working days after receipt of the information, the employer, or the test result, the employer must inform the employee or an applicant of a negative or positive test in writing. So you have to make sure that you give them a notice, a letter, stating whether or not they were positive or negative. For a positive test result, you also have to ensure that the employee has gotten written notice of their right to explain a positive test, or to request a confirmatory retest of the original sample. And that does not mean that they're going to have the lab send them the sample. They're never going to touch it. That means is that often employers will say, if you want to have another test done or a retest, you have the right to send it to another lab, but they're never going to get access to that test result. And it is the same test or the same sample. It isn't a new sample that I'm going to provide to you today.
Yep, it's just a split of the original sample would be sent out, determined to make sure there was no contamination possibly while testing the first one. Minnesota is also a second chance state. So first offenders, they go in and they come back positive. They have the opportunity to go to appropriate rehabilitation programs. Upon successful completion of that, they can come back and work. And when they do, they can be or fall under unannounced follow-up drug test, alcohol test as outlined in your policy. So again, we want to capture if you run into someone on the first offense and they do complete the program and they fall back in under the second chance, what are you going to do if the employee fails to do any of the set steps in front of them? If they don't complete a program, result in termination and or another positive drug test.
And that would be outlined in your policy as well. The last piece of this is really understanding that we have to protect the confidentiality of information around drug and alcohol cannabis testing. This isn't information that is going to be shared with anyone. You will have employees that will be looking to find out what happened to Bob or what happened to Connie at the, that they were in your office and that they say. We also have situations where employees might not be telling the exact truth of what happened. It is not the employer's role to correct that mistruth. Like, you need to not speak to it. All drug and alcohol cannabis testing information has to even be kept in a separate file. So it isn't in your regular personnel file. It is in a separate medical file. It is not information that is shared. So just to summarize, hopefully we answered some of your questions on Minnesota law and tried to make it more straightforward for you. But Minnesota law and OSHA focuses on impairment with test results. So really understanding, what does impairment mean? What does it look like? How can I ensure that we're doing that piece right? Employers also have to have a well-written policy that speaks to drug, cannabis, and alcohol testing in the workplace. And it is a best practice to have a lawyer review it, as we continue to go down this path, there will be people probably getting sued for people mishandling this. It is important that you realize your leaders do not have understanding of the signs of cannabis or drugs or alcohol, making sure that they understand what does impairment truly look like, and then have a good understanding of your policy. The bottom key line is everybody must consistently apply your policy the same. So that will be incredibly important as we move forward.
So key thing, educate, understand policy, reasonable suspicion, what that means. How are you going to identify it? Who are you entrusting with that? And then it comes to, again, making sure you're consistent across the board. Here's a poll for scoring the webinar. We always like to get information. We want to know, hey, did we do great? Was it very helpful to you? You have a couple takeaways, good information, or maybe we just missed the mark. We didn't exactly get what you were looking for. We're always trying to improve ourselves, trying to better ourselves throughout the process. So we appreciate you participating in that.
We did have a few questions that I just want to reiterate and make sure we're covering. Back to the policies. For a federal drug and alcohol-free workplace policy, does that also apply to suppliers?
So that is a great question. That one might take me to do a little bit more research. Typically, suppliers will fall in. Anybody that is getting money from a federally run or money coming from the federal government do have to comply. But the rules are very specific to who's covered under it. So I believe the answer is yes, but I will gather more information to ensure that we'll get the real specifics.
What if a
Great.
supplier comes on site and uses your forklift?
Yeah, they would apply.
They would apply.
Yes.
So,
Another question we had about medical marijuana specifically, how do you ask if someone is using that or has a prescription without violating HIPAA?
So HIPAA rules are really for insurance companies. They're not typically for employers. The only reason that you would ever need to ask is if you had somebody that was in a medical or in a safety sensitive position. That is typically where you're going to find that people shouldn't be using. So what you want to do is have it in your policy that if someone is going to need to use or become a patient, they should be asking for an accommodation. So that would be the line of what you would be speaking to, is not specifically to a person, but as a general rule, have this be, you have to request accommodations because employers should have an ability to understand, you know, what that looks like in relationship to the work being done.
Very good. A few questions on testing. Can GCs or controlling contractors require any testing in their contracts with subcontractors or require subcontractors to do post-accident testing?
So GCs rule the roost typically. So if your policy as a GC says that, you know, if you're getting federally regulated money, you are going to have to validate that everybody is following that Drug-Free Workplace Act. If you're not, and your policies state that we do, you know, pre-employment or we do reasonable suspicion or post-accident, what you would need to do is make sure that as part of your agreement, as you being a GC of bringing subcontractors underneath you, that they have to understand that they have to follow what your policy states. So you have the right to require them as part of them getting your project that they have to follow your drug and alcohol testing policy. They would have to adapt theirs to that environment.
Sure. Thank you. How about how many behaviors should be documented on a reasonable suspicion checklist before testing?
Yeah, that's always a great question. It really depends. I always will say, you know, two or three, because you're gonna see if you really take a look. You're often gonna see 2 or 3 things that are going on with the person, especially when you get into eyes dilated and some of those different things that are a little easier to catch. So don't just use one, and especially, you know, but 2 or 3 is typical. And you'll never have, unless somebody is really amazing, you'll never have them all filled out. I mean, the reality is nobody's going to have all of those different types of impairment because there's different drugs that cause different things.
and again, more than one, and it depends at times too, maybe on the severity of the impairment. So again,
Yeah.
it's at your discretion to determine, is it warranted for them to go in and take the next step of being confronted?
And who would pay for that confirmatory test if you have to retest? Is there any?
Your policy will state, most policies state that it's the employee's expense. At the employee's expense, if they want to do this, then they would pay for it to be done. But your policy is going to dictate that. And you need to speak to it, because if you don't speak to it, there's an idea that the employer will pay for it. But typically, I don't see that that's an employer paid scenario.
And I have one more question. I think with a post-accident test that has a positive test for cannabis, but maybe a low amount, would you still put that person through a rehab program?
This is a really great question, because impairment, a positive drug test doesn't always equal impairment, especially in the cannabis world.
Right.
So usually 5 to 6 hours after I use, that is going to be where I have probably the most impairment. So I think that is a difficult question right now, because you'd have to look for reasons like were there impairment reasons that caused the accident? Or was it that it was some other situation and then it wasn't because they were impaired, you just caught them with cannabis in their system. Your drug and alcohol testing policy should be or cannabis testing policy should be your roadmap and tell you how to handle that situation. You want to pre-think those things out and know how you're going to navigate them, because that will be what will rule. So if you say we test, we'll test, and if there's a positive test result ever, we will send you. You have to be careful not to say that if you're not going to do that.
So
verbiage is a key, and stay away from 100% of anything.
We always say with the policy and with the environment today in Minnesota and the policy and the different changes and that and interpretations out there, we always say, have a lawyer review your policy to make sure the wording and it's capturing the different rules and laws, and that will help with these smaller details too of how you want to word that or what you want to do. So,
yep.
And there was a question about off work time, like lunch hours and lunch break expectations. I would imagine that's policy as well.
Well, actually, lunch periods they are considered work time. So break periods, even if you don't pay for them, are considered work time, because it's all about where you're headed next.
Mm-hmm.
So that would still, it doesn't give people, you can't use on your premises, even if I'm 5 miles away, but I'm coming back, that still isn't an acceptable situation for me to use.
Sure. And then one last question about medical marijuana. If the whole company is a safety sensitive position, they work with heavy machinery, can they be asking anything about medical marijuana in the interview process?
They can't ask the question. What they can do is ask if they have any needed accommodations, and in your verbiage, spell out like, are you a medical marijuana or a medical cannabis patient, just due to the safety sensitive position.
Thank you. Yeah, that is all the questions we've had in the chat so far, and I think that about covers it. We're a little over time. If you have any other questions, please let us know. Reach out. We'll be sharing Connie and Dwayne's information here in a few seconds. But please reach out with any questions. We know that these topics are wide changing, and a lot of the answers are it depends. So please do reach out to either of these people or our OECS offices.
Thank you very much, everybody.
Yep.
Appreciate it.
Yep. Just a few other things. We do have a mental health in the workplace webinar coming up on Thursday, April 10th. You can sign up to attend that webinar on our website. So please look for that information. We'll also be emailing it out. And then we do just want to, again, thank our partners and let you know again that we are your total safety solution, and we love working with companies of all sizes to help find solutions to help them make sure that their people are getting home safe. And we do that by working with our partners, the TSSA, MPMA, SCSA, BIA of the Red River Valley, ABC, NRASP, Build Connection, and the Lakes Area Manufacturers Alliance. Thank you all for attending today. We hope you got a lot of information, and we will see you at our next webinar in April. Thank you.